welcome to the panel, Privacy Design, Dark Patterns, and Future Data and Speculative Futures as well. I'm Cristiana Santos. I am Assistant Professor at Utrecht University, where I do research in online tracking technologies and assess their legal compliance. And I also do research in dark patterns, mostly related to consent practices, and also applied to settings when users access their data within the right of access, and so access requests. And I work and collaborate with designers and with computer scientists to analyze the legal aspects, but also technical aspects of dark patterns. So I'm very happy to present the panel here today, focused on dark patterns or deceptive design, responsible design, and the usage of methods like Foresight studies and speculative design to anticipate future risks of data processing, anticipate potential harms, or understand existing harms from a different angle, from digital services and future technologies. In this panel, we offer a variety of perspectives. So from academia, from industry, from the DPS, the European Data Protection Supervisor, and also from a data protection authority, the CNIL, a regulator. I will firstly introduce each panelist, and each one of you will provide some initial remarks, and then we pass to the questions and answers, and then to your questions. So Ariana Roza, I will start with you. So Ariana is a research scientist at the Interdisciplinary Center for Security, Reliability and Trust, SNT, of the Luxembourg University. She's an hybrid, actually. So her research interests span across design, computer science, law, concretely privacy and data protection, and linguistics, concerning human aspects of privacy, legal design, online manipulation, and trust. She manages a national project in Luxembourg called Decepticon to detect and assess dark patterns, also from an interdisciplinary perspective. Ariana, the floor is yours for some initial remarks.
Okay. Let me try to see. I think you can hear. Yeah, hello. So hello, everybody. There's a lot of echo. Yeah. Maybe my opening statement is going to be about the goals of this interdisciplinary project that was just mentioned. We are 3 different research groups working on it. It has been financed by the Luxembourg's National Research Fund, and we are working, my research group particularly is working on cybersecurity and online privacy, so more from a computer science perspective, but we have a very close collaboration with the Human-Computer Interaction Group of the university and another research institute of Luxembourg, which is called LIST, where they basically do what is called data protection assessment engineering. So they do develop compliance tools, among the others. And just to give you a little bit of background of what we intend to do with this project, you can also find a page online. It's called Decepticon, Deceptive Patterns Online. We have many different goals. One of them is to study the effects of dark patterns on users, especially on special categories of users, so specific communities and groups. We also are studying what users perceive as manipulative, but also what kind of values and interests designers uphold when they design different technological products. Another goal is that of building a labeled data set. So we are building a description schema, what aims to be a future-proof description schema, also about emerging technologies, about dark patterns. So how do we actually, develop, how do we distinguish, how do we describe dark patterns in an objective manner? And we also intend to develop data science techniques to recognize dark patterns at scale and automatically. And thirdly, we want also to provide some tools and procedures to evaluate the transparency of, for example, of online interfaces, and in an objective, reliable manner. So in the end, it boils down to try to distinguish what is a manipulative practice and from what could be a legitimate persuasive practice in a reliable manner. And this is very important because manipulation, of course, as we know, is very often mentioned in many online realms. We're not only talking about online manipulation from a data protection point of view, of course, also consumer protection is involved. We're talking about fake news. It's, again, about manipulation. We also, from a cybersecurity perspective, when we're talking about social engineering, there are a lot of manipulative tactics used there. So we can really, let's say, draw a line across all of these different domains, which all rely on persuasive, manipulative techniques that act on certain users' cognitive biases. And this is very difficult to do. So to answer this question, how do we reliably distinguish between manipulative and persuasive tactics? Because of many reasons, I will just mention 2 or 3. One of them is that in many definitions that have been offered, also from a legal point of view, there is always the notion of intention. So we distinguish between these 2 kinds of practices out of the intention of the digital service using them. Of course, it's very hard to analyze the intention, especially ex post. So how can we get rid of intention? Can we rely on other kind of factors? Also, one of the tensions that dark patterns expose is between the immediate benefit that they offer to users, for example, in terms of immediate gratification or free access to an online service and many others, and long-term, much more abstract consequences, negative consequences, which are sometimes even very hard to determine ex ante. And just to finish, maybe another point which is very dear to me is also how can we rely not on the intention of the service, but on externally observable features in order to distinguish dark patterns from other kinds of patterns? For example, there are a lot of also legislations talking about visual elements like the colors of buttons or the size of buttons, and we're just wondering whether there is much more than that or something more reliable that also in the future will still hold and be able to, or help us to determine what is a dark pattern or not. And maybe I think I will stop here and then we will see later whether we can pick up some of these points. Thank you.
Thank you, Ariana. During the panel, we will unpack some of the concepts that you have disclosed just now. I will pass to introduce now Dusan. Dusan is a seasoned privacy professional with experience in private corporations and public-funded research and development projects, for example, Horizon 2020 and within the United Nations. He works as a senior data protection consultant at White Label Consultancy, and previous to this, Dusan was working in the online gambling sector for more than 1 decade, and within this panel we will have the opportunity to hear some insights on how to incorporate transparency and transparent designs within companies. The floor is yours, Dusan.
Thank you, Christiana, and first of all, thank you for inviting me for this panel and the conference. So, just to present briefly myself, as Christiana told, I work as a data protection consultant. I work in the industries, different type of industries, primarily focus on hospitality entertainment industry. Before I actually became the consultant, I have been working in online gambling industry. Before, industry, I was working also in academia where I was researching the legal and data protection aspects of online gambling industry in Europe. So when actually I was invited for this panel, just, I was wondering, okay, what I can actually speak about dark patterns here, but very easily we found a common context, between what is going on in the industry, what is going on in the academia and research field. The fact is that I have been practically dealt with many, let's say, projects and programs that were developing some sort of incentives, to attract the people, to attract the traffic toward, for instance, online gambling, service providing. And that's actually quite legitimate from industry perspective, and commercial perspectives. Also, what is, one of the insights I would like to actually share with you is about some sort of the, let's say, convergence between different types of industries that are well regulated per se, but their actually interrelations are not so. And I personally see that this kind of let's say, links between different type of industries and integration of different type of industries brings the huge potential for very lucrative and lucrative projects. But on the other side, this kind of the cooperation might affect really consumer behavior that ultimately lead to, let's say, different consequences to consumers that might be also adverse. Cooperation, we will speak more about these later. And also, as you mentioned, I just would like to share some of my actually practical experience concerning, transparency internal transparency in the different industries, and what data protection and data processing means really to different stakeholders and ordinary employees in industry. And last but not least, we may actually just touch upon some things concerning, how these kind of dark patterns, how they are perceived by stakeholders, and what is actually, how to explain them, and what is actually this kind of the regulatory discourse that actually concern the dark patterns, and how actually they are wrongly perceived and not perceived at all by those that plan this kind of the, let's say, business projects. For now, that's all for me for now. Just we will speak more later.
Thank you, Dusan. I will present you Kenneth Bowes. So Kenneth is a designer and a technology ethicist. He has been working as a consultant on responsible design and technology ethics. He has 20 years of experience in industry in high-level tech firms like BBC, Samsung, Twitter. He's the author of the book Future Ethics, and he has spoken on responsible innovation at Facebook, Standard University, and Google. And during this panel, he will offer some insights about what is responsible design. The floor is yours, Kenneth.
Great, thank you, Christiana. Hi, everyone. So, yes, I'm Kenneth. As you heard, I'm a working designer with about a couple of decades inside Silicon Valley in the UK tech industry. I moved into ethical design, ethical technology a few years ago because I was frankly dissatisfied with our community's responses to it and the abrogation of responsibility that I thought we were all complicit in. Obviously, there's been a lot of growth in technology ethics and innovation ethics in the last few years, which is promising, but I also think it's still rather tightly bounded, and it's not infiltrating the parts of technology firms that it really needs to reach. We have responsible AI teams, for example. We have privacy and data protection disciplines within these companies, but these issues are still not really reaching where the rubber meets the road, which is inside design and product teams that are making real product choices. So, for example, if I were to ask working designers what the implications of Article 25 of GDPR in data protection by design, what are the implications for their work, I can assure you that none would have a clue that that regulation even exists. They will see legal essentially as a shield to prevent them from any accusations of doing wrong by that article, but it is not changing the way these products are actually being built and planned by designers and by product managers. On dark patterns, deceptive designs, I think there is a little bit more awareness, particularly among designers. But even then, operationalizing change here is hard. How do you turn a desire to do the right thing into new ways of working? There's still not a whole lot of evidence that that's really happening. So I think the work of this community and of events like this, from what I see, is very promising, but it is not done until it reaches those people. It will always be seen as reactive, as defensive, focused on compliance and constraint. So essentially, I think we need designers and product managers in this conversation, in this room, because ultimately they hold the most power over deception in interfaces and so on. I have a particular interest in using techniques from the futures and foresight space, such as speculative design, which is essentially just designing hypothetical things so that you can talk about them before they happen, as a way to tease out potential implications of new technologies. And so I think there's a very interesting link about how we can use speculative techniques, futures-leaning techniques, to involve a wider public in the conversation around manipulation, deception, privacy, and so on. So very interested to see where this conversation goes today. Thanks.
Thank you, Kenneth. I will present you Regis Chatelier, and representing the CNIL, Data Protection Authority. So Regis is an Innovation Foresight Project Manager at the Department of Technologies and Innovation of the French DPA. He is a member of the LINK Innovation Laboratory at the CNIL and is the author of the very known report from 2019, Shaping Choices in the Digital World from Dark Patterns to Data Protection, the Influence of UX, UI Design on User Empowerment. Would you like to share some initial remarks, Regis?
Yes, thank you. Hello, everyone. So at CNIL, I would say that online manipulation is not a topic as such, but since we are dedicated to data protection, but we had the opportunity to tackle the online manipulation through different publications. We had a report on ethics of algorithm, which was published in 2017, in which we pointed that some algorithm could have implication for the rights of the people and on manipulation, and also on dark patterns, which are used to trick users, clients, or citizens. And we work not alone, we work also with some other authorities in France, such as the ARCOM, which is a regulatory authority for audiovisual and digital communication, and Autorité de la Concurrence, which is a French competition authority, and other ministers or public institutions. And we took part to some discussions around the DSA and the DMA, for example. And regarding what we have done at LINK, at the Innovation Laboratory at CNIL, we published indeed the 6th Innovation and Foresight report, which is what's called Shaping Choices in the Digital World from Dark Patterns to Data Protection, the Influence of UX and UI Design on User Empowerment. The idea was to explore the challenges related to the design of digital services and to give some policy recommendations. And we pointed the necessary control of design and architectures of choices. And our idea in 2019, we still have the same idea, was that design should be at the center of the regulators' concerns, just as it is already at the heart of the relationship between individuals and service providers. And since then, we have launched many different projects. We launched in 2020 a platform which is called Data and Design, which aimed to introduce the GDPR to the designers so that they can understand what are their missions under the GDPR on transparency, on the consent, on the rights of users, so that they can understand not the old GDPR, because designers don't have to become lawyers, but just to understand what are their role and what could they do, and to be understood by the DPO and by the marketing services, for example, or marketing department. And on this platform, you can find some use cases, some information, and some examples so that the designers can use it. And more lately, we took part to the redaction, the writing of the guidelines on the dark patterns in social media. And we have launched many different projects with researchers, and with we are going to work in the months to come with some behavioral economists on what are dark patterns, what are the effects, etc., etc. So it's a real topic at CNIL, and we have many different projects, as well as the general mission of the CNIL on case by case. If you receive some complaints, or if you have some cases, but dark patterns are now a real topic at CNIL.
Thank you, Regis. Stefano, finally. So Stefano Lucci is a legal and technology expert at the European Data Protection Supervisor. As a lawyer working in the field of data protection and AI, he complemented his legal background with IT skills and foresight capabilities, which is something that is new within the EDPS. Stefano, some initial remarks.
Yes, thank you very much, Christiane, and thank you all for inviting us, the EDPS, at this panel. And I also thank you for participating so numerous. We have to say that we are very happy about this. Well, what to say? This part of the table is more about foresight. No, it's complementing a bit the discourse we had also in the other years of CPDP on dark patterns. So, better to start a discussion about these foresights from zero, because it's exactly what we did at the DPS when we decided to ground somehow the new strategy on foresights. So the main word we have to consider, and we consider at the DPS to start this new journey, is preparedness. And preparedness sounds like a principle that we should have in the GDPR, but it's something that still needs to be explored in deep. And our work started really from an introspective, from a moment of introspection that lead us to resonate a bit on what happened in the last year, because we've been confronted with many challenges. We've been confronted with COVID. We've been confronted with what is actually happening at the eastern border of the European Union. And we understood that we could have been doing something. I'm not speaking strictly about the EDPS, but it's also a political discourse that is happening in Europe in general, at the European Union level, especially in the Commission, for example. All these problems we were faced somehow triggered something worse, like an electrical shock on us. No? The discussion started from here, and from the question, what can we do in advance to understand things happening and to be more prepared to those changes that are coming? Somehow I see this as a bit of a fil rouge about what also my fellow speakers said so far. The discussion from here went to the understanding that actually we could have done something, that we have a room for maneuver, for really nudging the developments toward a certain direction. And from here we started a set of projects like Sonar that maybe you've heard something, but I will share with you details afterwards. But all this is grounded on this new word that is foresight, and maybe just a few moments for defining what foresight is. And to us, foresight is really a discipline that deals with exploring, anticipating, and shaping the futures that are in front of us in order to find ways that are more sustainable, find ways that involves data processing in a more sustainable manner in a broader sense, that not just a strict legal sense as we were discussing before. And this leads us to understand that maybe instead of only reacting to changes, we can really move to a more proactive approach that can lead us to anticipate, especially the technology developments in our society, in order to prevent risk to transform in harms, but also to nudge developments toward a more value creation process, to enhance the value creation process. So preparedness to us means this, and we will elaborate better later on. Thank you, Christian.
Fantastic. Let's start with some questions to our panelists here. Ariana, I will start with you. So the UCPD, the GDPR, and the promised DSA are all venues to regulate dark patterns. So let's focus on one, the DSA. Specifically recital 39A and Article 13A, they provide a general prohibition of dark patterns. Allow me to read to set us the common ground. So Article 13A says, providers of intermediary services shall not use the structure, the function, or manner of operation of their online interface to distort or impair recipients of services' ability to make a free, autonomous, and informed decision or choice. So my question is, are there actually free, autonomous choices? Is language or design neutral? I remember from my studies that already Alessandro Acquisti mentions that there is no such a thing as neutral design in privacy or in security or in any setting. So if there is no neutral design or neutral language, how can we assess what are persuasive designs and language as well, and how can we distinguish them from manipulative settings?
Yeah, maybe something that we can also speak together with the other panelists. But yeah, I think this is, I don't know, it could be a kind of problematic quote or definition. Of course, you need to define, so you need to find the words to do that. And no, there is no such thing as a neutral design or a neutral language, that's for sure. So it's also interesting that in the ADPB just published guidelines on their patents as well, and there is again this mention to presenting information in a neutral and objective manner, which is very laudable because I think it refers to the fact of, for example, not framing information only in a positive way or only in a negative way, so that you don't unduly influence users in their decisions. However, probably it does not happen. It never happens that we ever use a neutral language to describe something or neutral design. So it can be, let's say, interpreted in many different manners, and that's probably problematic. Another thing that is a bit problematic about the definition there is the prohibition to use nudging techniques, of course, through the use of dark patterns. Again, the dark patterns are not defined. We're discussing over lunch whether it's a good thing or a bad thing to define dark patterns. It could be good if you want to use it as a legal instrument, for example. It could be bad if you want dark patterns definition to be future-proof. Again, so to not only refer to, for example, graphical user interfaces, but to refer to a lot of other new ways of interacting that we are having and we're going to have with technologies. So only, for example, referring to visual nudges is probably important for now, but is, again, a bit limited and limiting. So according to me, there are certain definitions that are very useful, but yes, they're very limited, and we should really think a bit much, let's say, farther away along the line of emerging technologies, for example. Maybe you have something to say about that. And maybe something that I was wondering is, there is a PhD student working with us, and she is called Rachele Carli. You can look up her work, and I think it's pretty good because she's looking into the manipulation of human-robot manipulation. And so, not talking about graphical user interfaces at all, but we're still talking about the same. And as I mentioned before, there is also a ban on manipulating user in the AI Act, at least in the proposal. And again, how do you define manipulation? How do you define undue manipulation? So I don't have an answer for that. Maybe what we're trying to do, I can explain it a bit better, because it would be great in this audience. Probably there are going to be people that could also help us to define what is a manipulative practice and what is a legitimate persuasive practice. I'm thinking about you, Catalina, but I'm also thinking about other people here. So what we're trying to do, for example, in order to define this description schema about our patents is to interview and involve in our studies different communities of experts. So, of course, I think we are all agreed that we cannot just regulate or just analyze this phenomenon from a legal point of view. We need many different expertise. We're now running, for example, expert interviews with data protection experts, but we're also integrating this work with more participatory studies with the designers to really try to elicit what kind of values they embed in the products that they design. We were also discussing earlier that digital ethics is for sure an angle that we cannot ignore, but also we're looking at, for example, international standards about privacy principles and design. So we have a working hypothesis that by putting together all these different views, we may have, maybe, hopefully, a definition or at least some kind of, let's say, objective attributes that we can use in order to categorize dark patterns or in order to distinguish them from other kind of designs. So interdisciplinarity is one of the cards, let's say, that we are playing here. But honestly, I have a lot of critics. I don't have so many, let's say, constructive comments for the moment about this. Just to sum up, I would be very careful about using words like any kind of visual nudge or any kind of, or whether there is such a thing like a free, so without constraints, autonomous decision. What does it mean exactly? Can we really have autonomous decisions? In which context do we take decisions? I don't know, I would be very wary on using those words, maybe.
Regis, at lunch we were discussing whether it is possible to have a freely meaningful choice. Can you comment on that, please? Because your comment was very interesting. Indeed, it's possible to have a freely given choice within a set of choices that are given to the user.
Yes, that's why I was talking about architecture of choices, because when you have to make a choice online or offline, you have to make a choice between some choices which were created by someone else.
That's already created by the online architect.
Yes, and that's why the free autonomous choice is not a good word, because you have the right not to choose, but not to do anything you want. You know, and if you don't want to use the service, you have the choice not to use the service, but you can't change the service so that it can work as you would like it to work. And that's why the free autonomous choice, as such, is not a good word, but it was just a conversation.
Word.
Yes, but we are in the conversation, and that's why we, in our report, it was dedicated to the architectures of choices, and it was by Kasselstein, if I remember. Yes. And because you can't have a choice, it's a choice between choices possible in an IT system. And if the IT system doesn't have this choice possible, it's not possible. Okay. If the data processor have some different options, you have to choose between options. And that's why every time you have some choices between some possibilities made by others. That's why you can't change everything. And you can do it, building your own system. But that's why it was the point. So every time you have to choose between some choices created by others. That was the point for our discussions.
Thank you for that clarification. Kenneth, designers and developers are concerned with product development and with a high level of interaction engagements with some service or a product. And therefore, it's deceptive design is somehow normalized by designers. And that make actually deceptive design more normalized. Is the responsible design a niche within companies, or is a reality? And actually, what are the incentives for the industry to hire you or any other technology ethicist?
It's always nice to have a question like that, right? Justify your existence. So I don't think it's necessarily fair to say designers have normalized deceptive designs. The incentive structures around them have made it harder to resist, shall we say. I actually think the concept of ethics is quite an easy sell to designers, particularly because they already see themselves as beneficent, as in it for the good of the species. You know, it's quite an easy sell for designers, less so for product managers. I see responsible design as an understandable and necessary reaction to some of the exploitation that we have seen inside technology firms and some of the misalignment of values that's happened and is evidenced by what we've seen, frankly, in Silicon Valley in the last few years. Is it still a niche? Yes. It is still a nascent space. I mean, as I mentioned in my intro, there are tranches of kind of responsible thinking, I suppose, within tech firms, but they're often quite tightly bounded, particularly into AI ethics and responsible AI initiatives, or particularly into data protection and privacy teams and so on. That mentality, I think, has not yet spread into the heart of product-making decisions. So this is my justification for existence, is to try and help organizations understand that that is not optional, right? That is necessary, that the people making these decisions, the people with the most power, frankly, in these organizations are mostly product managers, designers and engineering managers to a lesser extent, that they need to be taking decisions that not only privilege business needs and even user needs, but also the needs of other stakeholders, including non-users, societies, communities, neighborhood cities, non-human life, even the environment. There is a lot of work to be done on that. But an organization that successfully does that will, I think, obviously benefit from reduction of risk, of brand toxicity, or particularly talent risk is a really important lever I pull at the moment. Employees are really mobilized around this stuff. So you want to retain and attract the best possible people. They care about ethics these days. They're pulling together for this kind of stuff. So this is an important thing you need to reflect. So risk, reputational, brand, talent risk, regulatory, of course, is a potential risk. But the final thing I'll say is I think it's important to invert the message a little bit on responsibility and ethics. It's not just about defending against harms. It's also about seizing opportunities, how we can use this to truly differentiate, to stand out in marketplaces full of exploitative Me Too products and say, we're different, our values can be seen through the decisions we take and the products that we build. And that is a really powerful advantage.
A curiosity, if deceptive design has an interdisciplinary dimension, should designers also have some training in legal compliance or in privacy compliance?
I mean, in an ideal world, sure. I would also want then the lawyers to have a bit of design training as well. I mean, the problem is that I'm not joking. I mean, there obviously are practical limits in terms of who can be in the room. Certainly those disciplines need to be able to communicate more effectively with each other, let's put it that way.
And work together.
Yeah, for sure.
Thank you. Dusan, you represent the corporate side of this panel.
Yeah.
Do you think that the current legal and data protection framework constrains the business modus operandi, which may lead to manipulative practices?
Okay, it's not an easy question, very tough, and there is no yes and no answer. But I will try to actually try to provide a little bit broader perspective, for instance, on some industry that was my bread and butter. It's online gambling. And this kind of let's say, manipulative, deceptive practices are supposed to be regulated by, in contemporary online environment, by consumer protection law and data protection law. And they are supposed to be hand by hand. But actually, let's see what is the case in online gambling in Europe. In Europe, actually, there is no European Union online gambling law. The principle of subsidiarity is applied. That means that 27 European Union member states actually regulate this field in accordance with their national policies and whatsoever. Even more, there are some federal states actually regulated on the regional and state level. You have dozens of different sources of regulating consumer protection in the domain of online gambling service providing. Okay. This, according to my view, this field is really over-regulated. That means that consumer protection, for instance, marketing activities are so regulated that, as a typical compliance advisor or manager, you really have to take care about, the color of advertising parole, the specific language you use, and so on, the phone number of the, let's say, supportive organization, et cetera, et cetera, et cetera. But it is quite but in every day from the consumer perspective, you can actually deal with this kind of advertising parole of different, let's say, platforms, even those that are appealing to children, unfortunately. And how it happens, according to my personal belief, that is the consequence of really cooperation between, let's say, several sectors. For instance, media and sport industry closely cooperate with the online gambling industry. So, unfortunately, my personal feeling is that, consumer protection law is very sector-specific, and they regulate this, that, and that sector very strictly, and it goes to over-regulation. And usually, the user experience is inappropriately followed. So, regulation don't follow actually how some user ended up somewhere. Just they starting from the point where someone actually finish up in online gambling service providing platform or hotel accommodation service providing, whatever. The roles of intermediaries actually are very important, I think, in the contemporary online environment. And where is the role, for instance, of media? Media actually brings the traffic, and in this gap between gap between sectors, and sectors cooperate very well in the business perspective, there is actually huge possibility for manipulative and deceptive techniques. Unfortunately, as it was said already, some of the, not some, but many of the GDPR provisions in general, European Data Protection Framework is composed of, let's say, legally non-binding, sources. Then some sources that are still quite abstract in general, and for me as a data protection practitioner, very difficult to actually translate is something that is, solution-based, something that I can give to the business owner and say, you have to do so. Or it is, better to do so because you will have some kind of advantage on the market because of that and that. Just to come back, to what I started. On one side, consumer protection law goes in details and create a set of the perceptions among the business stakeholders that they are clear from the consumer protection law perspective and the regulation, what they have to do. Okay, this provision says that and that, we should do this and this. In data protection domain, situation is very different. And you as a data protection practitioner, you really have to, exchange a lot of arguments with, different stakeholders in order to explain them that to be pro-privacy oriented, that at the end of the day might actually prevent, creation of deceptive and manipulative practice, whatever it is actually. Actually, it's something that, creates some sort of a regulation paradox that, practitioners it's very difficult for us to deal with. So, as I said, I cannot give you yes and no answer, but this is generally my opinion, from my perspective.
Thank you. Yeah. So, I would propose for us to think all about the future of privacy and data protection. We have so far several relevant documents issued by policymakers. So we have the recent guidelines from the DPB on dark patterns within social media interfaces. We have a white paper from BEUC on dark patterns as well and consumer acquis. We also have two documents, quite recent, a reviewed one from the ACM, the Netherlands Authority for Consumer and Markets on persuasive design, and we also have a very recent one from the UK Competition and Market Authority. Do you think, and this question is addressed to all of you, whoever of you wants to answer to it, do we have guidelines and or reports or regulation that are future-proof or that are flexible enough for future technologies and the harms and the risks of data processing technologies? Because as of now, these current guidelines and regulations are mostly UI-based or UX-based or dark patterns text-based or even code-related based with bad implementations of code. But potentially in the future, let's imagine within the realm of 5, 8, 10 years, maybe this interface might be seamless. For example, with robot interaction or with voice speakers or with the digital twin. Are current regulations future-proof? Are dynamic and flexible enough? What is here the interaction and the medium? Because also, what are the risks of manipulation? And because these seamless interfaces might be more difficult to track and to audit as well. Any comments on this? And then we jump to Foresight studies.
May I just add a few, what we were actually discussing during the lunch. While I was preparing myself for the panel, and I was speaking with someone, and we were speaking about concrete industry, concrete service provider, and just was thinking about take it as example for presenting here, and and the comment from the typical lawyer was, hey, but they're not doing the dark partners. Why? they're not doing nothing illegal. Okay, that's actually very quite problematic. You know, you asked the question, okay, but your question actually should be observed from different perspectives. How usable this source should be, to whom should be. You know, one issue is if you actually, observe this as a data protection practitioner that works in industry. Another one is actually if you're doing the research, if you're doing the development of further sources, the regulatory sources, and so on and so on.
Kenneth, do you have a comment on this interaction and intermediation between the data controller and the user, the data subject?
Not so much on that, but maybe just to add to what Dusan's saying there. I think emerging technologies are frequently born into, if not a legal vacuum, but certainly an unclear legal environment, right? It's hard to anticipate on that kind of concrete level everything that might happen. And industry likes to pride itself, frankly, on saying that it's always a decade ahead of regulators. The law is also, as Dusan's saying, is not a suitable moral baseline. It's not enough to say we comply with the law. You will still have reputational issues. You'll still make all sorts of people and stakeholders unhappy by doing things that are compliant with the letter of the law but immoral and unsustainable. So this is why we still need that space for ethical decision-making within technology firms, obviously with regulatory oversight and so on. And so this, I think, actually tees up where we're headed with this panel, is right? This is why we have this need for speculation and foresight within these companies, as well as within policy and regulatory environments, so that we can ask that fundamental question, what could go wrong, and then try to anticipate those harms and mitigate them before they happen.
Thank you. Stefano, yesterday I heard in the first panel of dark patterns, this is the third panel, and we will have the opportunity afterwards to hear the fourth panel on dark patterns with Catalina and with Mark Liza, etc. And I heard Finn mentioning that DPAs are meant to fail today in enforcement due to low capacity. I wonder what are Foresight studies and what actually Foresight studies can do to help to reach a more effective policy making and enforcement of the GDPR.
Yes, good question. Huge point, I would say.
We prepared well.
Because the let's say first of all, to be understood that Foresight is a toolbox. It's also a new kind of toolbox in the hand of the data protection authorities, where for the DPS for sure, CLEAN was a lot working by a lot of time on this. But I want to stress one specific comment on Foresight, that is the possibility to imagine a different set of futures with the S and the end. When we conduct, the public discourse about a technology, about an issue, about whatever we consider in the data protection sphere, we usually tend to agree on one scenario that is the most commonly understood and the most agreed. But actually, Foresight can really help in leveraging on a lot of different sources, on a collective intelligence to find a set of diverse conclusions, diverse scenarios where we want or when we don't want to end up. So this can clarify, for example, even the definitions, as we were discussing before, of what is and what should not be something related to dark patterns, for example. So we see this as a more general tool, not specifically only to this field we are discussing here today. In general, maybe if I can ask to show the few slides I prepared. In general, at the DPS, we've been firstly working on a very preliminary project that was stopping itself in the first part of the Foresight capacity. We wanted to somehow understand which are the technologies that are coming, which are the technologies that worth monitoring today, in order to be prepared for what will happen tomorrow. And if we move to the next slide, please, we can really see, the next one again, sorry. We can really see the effort we've putting, sorry, next slide, please. Thank you. in developing this Tech Sonar project that I was mentioning before. And Tech Sonar is inside our duty to conduct a technology monitoring process. It's a, thank you, perfect. To conduct the technology monitoring process. It's within the duties of any, I would say, data protection authorities around Europe. What we did here was really to find a way to move into a new approach, into a new way for working, into a new way for monitoring what was happening around us, with an added agility in doing this, with a new way for processing the waterfall of information we need to process for understanding these developments that are coming. No? We ended up in this project that at the end is a tool for knowledge management. Started from this and ended up in something that actually is provoking a lot of discussion. To be paired with Tech Dispatch, that maybe it's well known by 2-3 years now, that is a set of publications that goes in depth on one specific technologist that are chosen possibly from Tech Sonar that goes more on the surface level. The idea is to be very quick and agile in scraping the surface, in monitoring the evolution of the technology landscape, in scanning the horizon we have in front of us. So this is, we don't have time to go in deep. This is our methodology. If you are curious to know more, it's published in our report. But what I want to show you here is the fact that if we talk about one specific technology, or if we talk about one specific application or design patterns, the process is almost the same. It is a way for putting together the information we have collected, the use cases, the opinions, the different stakeholders' point of view, in a way to find a set of scenarios that can or cannot be followed. In this sense, the first step we did was to select the 5 technology, and then we got 6, thanks to the the wonderful work of our colleagues that volunteered on this. And we are working on the next report that will cover 2022 and 2023. For Foresight experts, this time horizon is a very strict one. Usually, we need to work to a longer one, as Regis, I'm sure, will comment. But the idea here was really to help our colleagues to be prepared on what will come next. So the idea is really to work in a more anticipatory and not only full reactive approach. This is just quickly the report we published in December, where we also shared the methodology. We had a call also by Mr. Wojciechowski to start engaging with stakeholders in order to develop a plural views on the methodology specifically to be run and to be shared in context like even CPDP maybe next year, an idea for the next year. But the huge issue we had was how to manage the waterfall of information we need to process to lead us to a meaningful conclusion. So thanks to the JRC, the Joint Research Center colleagues, we've been using let's say, ethical small machine learning tool that was really scanning in patents, scanning in open access academic publication, and also in EU projects in order to extract the value we needed. And those tools was really a huge effort we made for ending up in the next for the next report we will have in June actually. And we had discovered a lot of things, like for example, if you look to the for example the metaverse, no, that is the new buzzword from 6 months so far. You discover that you have trends of something happening in the research field, in the patents, that is going by 2008, and actually is it's diminishing in these days, even though we have the feeling that metaverse is something very new. Yeah. And this is very what we can gain from data, from machine data that we complement with human intelligence. We need to do this. We need to add on top of it the sensibility we have, the experiences we have, the different backgrounds we have at the DPS in general. Also, not only in the technical unit where I'm working, but also involving colleagues that are more expert on policymakers, on policy making, on legal issues, on court decisions, and so on. So the idea is really to integrate trends that are coming from different sources. In general, how, just to one final word, how this could help enforcement. Well, this is something we are also discussing internally, and we will have a lot of points about this in the conference we will have in June. Bit of a marketing advice, be there and subscribe. But the idea is really to shape.
Nudging.
Sorry.
You're nudging us.
Absolutely, yes. Not forcing, nudging. But the idea is really to find a new way even for enforcing. So we will try to develop the concept of anticipatory enforcement close to the concept of anticipatory compliance that we've been working on with colleagues I've seen here in the panel fit event we had in March. And the conclusion was the need of augment the comprehensibility we have in the system. I mean, the difficulty that you were discussing before of data controllers and processors in understanding the needs, the concrete, how can I say, implementation of very high-level principles. It's something that is nowadays totally on the data controller. Foresight can really help in finding a common ground, a new ground for discussing how to actually implement this principle in practice. And this is an issue that has been also highlighted by the Commission in after the 2 years report after the GDPR went into force. And I leave it this
Thank you.
to hear, but ready to discuss afterwards.
My last question. Regis, maybe you could answer, what is speculative design and how does Link use speculative design and foresight scenarios to prevent risks, data processing risks?
Yes. So just to explain you more about the Innovation Foresight team, at CNIL we created the Innovation and Foresight team 10 years ago. So we have published a lot since then. And we have published 8 Innovation and Foresight reports. The one about design, it was the 6th. And there is one more, I think. And every time we republish, is that the idea is that the team needs to act proactively before the adoption or widespread of use of technology, and before one topic or one big issue comes to the core of CNIL and has to be investigated by technologists and lawyers. And as part of our toolbox, we integrate design fiction and speculative design methods so that to support more traditional foresight analysis techniques. And we also have a website on which we have a Foresight Watch, and we publish some analysis, shorter analysis on many different topics on a weekly basis or monthly basis, it depends. And every time we publish a report, we try to incorporate some design fiction and speculative design. So just to explain you what is design fiction. Design fiction is a fictional artifact such as press articles, can be a scenario, an object, a digital object, an app, a service, or sometimes an ads, who are not real, they are fake, and they are not treated to be seen as real scenarios. But the idea is to part from the reality of existing cases based on every trends, on weak signals and pieces of fictions, because we use a lot of the real science fiction fragments we can find in literature or in movies, for example. As creating these artifacts, the idea is to predict the future. It's not to predict the future, but to challenge what exists and what is plausible, what could happen. So the main idea is not to predict the future. We are not here to tell you it will be like this in the future, but just to make you imagine and to make you think out of the box and out of your daily life, out of the law, because we try to forget the law when we create some design fiction. The idea is not to think within the GDPR, but in the future. And we don't know how the future will be. So the main idea is to enable people to see and experience everyday life in speculative afterwards through the materialization issues of controversies with the idea and the goal of creating discomfort and to explore new territory to stimulate situation and to encourage exchanges. And to give you some examples, with every report I showed you, you have some different examples. We created some design fictions about smart city in 2017, and I will present you more what we created when we published about design. And as you told us, the report was about UX and UI design. It was more the visual design. And what could be the dark patterns are really thought in terms of visual design these days. And we knew at this moment that an interface is not only your screen, not only a small screen or big screen, but can be different interfaces. And in this example, which is a fake interview in 2032, I think, if I remember, it's on the new targeted trial, and that in the future, maybe the marketing will use the way we think and just to make us think differently, but for real, not just with some visual dark patterns, and to optimize our brains with neural connections so that we could make some choices which are good for the company, for example. And we had some other examples around vocal assistant, for example. And this one, just because it was more funny, which is a Tamagotchi IA or AI, AI is IA in French, which watch over your privacy. It was the new Tamagotchi, because if you remember in the 90s, we had a Tamagotchi to take care of its life. And in the future, maybe we will have some Tamagotchi who will take care of our own privacy and maybe on own life. And maybe it can be a different interface. And as we try to live in a world when we try to be more competitive, more efficient, and more privacy efficient, maybe we have some such systems. Which what is interesting in this system, it's about privacy. It's a bit scary, but the idea is to make your life better. And the idea is to make you think. Sometimes you have some ideas which sounds or which looks like good ideas, but if you try to think further, to think more about this apparently good idea, you are going to find what are the boundaries, the limits, and how could we try to think more on our goal and how to reach these goals.
Thank you. Do we have questions from the audience? Please, here.
Hi, my name is Robert Poe, and I'm from the LEADS project, where we teach data scientists law and law to data scientists. So I'll make a comment earlier. But okay, so my question is, how can we prevent speculative futures from becoming dark patterns in and of themselves? Okay, so if you're thinking about, when I think about speculative futures, well, okay, so if we think about past actions, we can track the causality. Like if we go to the ground, we can look at the past action and track the causality to see whether there was a connection between the policy action and what actually happened. But by definition, with speculative futures, that would be impossible, of course. So then two policy concerns come up, and I'm wondering if there's safeguards for this. So the first would be, it becomes important that you consider who's developing the speculative future and what values they hold or ideology they have. And then the second concern, especially in the future when speculative futures are, let's say in the metaverse, right? Like the speculative future, you would actually go into virtual reality and you would feel like these imaginative effects, right, of whatever policy choice you're making. This would be very good for the kind of...
Maybe you can resume because it's
sorry.
hard to catch up.
This would be very good for the kind of... sorry. So for the kind of things that are very emotionally appealing, speculative futures would work well, but the kinds of ideas which are less sexy, less emotionally appealing, those might be ignored, even though they're equally important.
Regis.
I tried to answer, but I think that when we create some speculative design or design fiction, a good design fiction is not a design fiction which shows you what is good, what is wrong, and what is a good future, what is a wrong future. It's just to make you see, we try not to incorporate moral judgment in our design fiction so that the people can think by themselves. And but on your questions, I think the main risk is that speculative design is becoming trendy, and the risk is if everyone makes speculative design on everything every day, it's like design thinking some years ago, and it's like a big market, and we don't know anymore what is design fiction, what is not, and it's the most important risk, I think. We have to take care to do this with an idea of how could we use it in our mission. It can be as a DPA or as a company, just to use it, not only for as a tool of marketing, in my opinion.
Do we have more questions from the audience?
Can I
yes.
maybe just add to that? I mean, so you may be familiar with Google's Selfish Ledger program. This was actually, it was X rather than Google. This was a piece of speculative design that they'd worked on that was leaked to the press, and it caused kind of an uproar because it was morally ambiguous, shall we say. It contained multitudes. It had some good things, it had some bad implications as well. One of the reasons that caused problems is because it was shorn of its wrapper, and the wrapper was the explanation of the point of speculative design. This is not saying we should do this. This is a depiction rather than a prediction. It's a depiction of a potential future that we use to tease out concerns, opportunities. Regis is right that these aren't necessarily moral objects, but you can use them for stimulating conversations about morality and ethics. So if it's shorn of that wrapping, then it can be, oh, well, Google is saying we should do this, and then some product team picks it up and says, that's a great idea, let's build it. So you need to make sure that that kind of caveat, I think, is embedded around that work in a way that it cannot be sort of, ripped off and then just leaked or posted somewhere where it suddenly looks like a prophecy or a roadmap, which is obviously a very bad place to be.
Thank you.
Can I also add a very unpopular point to anticipate the Gian Claudio question? No, okay, go ahead. No. Yeah, quickly, very quickly. This can be, as a lawyer, very well integrated in the data protection impact assessments. A moment, that is, okay, very legalese aspects, but I see a lot of potential of using speculative design, scenario exploration system into the understanding of risks. Mm-hmm. If you can imagine a situation that is diverse from the one you have, where risk can be better managed, let's say. Voila, justice.
Very rapidly, so Giancarlo Mangieri, Elect Business School. As a GDPR nerd, I think there's something that might be, it was a fantastic discussion, but I wanted to ask in particular to CNIL, to DPS, etc. What about fairness principle in GDPR? We all, we talk about it, we never use it. This might be the first, we could start a case law just based on Article 5. I know it's very general, but if I think at an application of Article 5, I would think dark patterns, right? Mm-hmm. So I know that there are problems for, competence and island and whatever, but don't you think this might be in addition to consumer protection and to the SA list and to the AI Act Article, 5? Do you think there might be a place for enforcing Article 5, or is it too difficult?
No.
I don't know if there is the answer, but I will answer with answering another question about now, because the answer is inside, I think. I'm not sure I can answer it, but when you talked about the recommendations, the guidelines, etc., if they are well suited for the future, I think we have just to know what is the text, what is the GDPR, and not the recommendation. And the GDPR has to be used now or in the future. And it's not because we have not used enough the Article 5 now that we can't in the future. And that's why I think it's important not to just to watch the recommendation or the guidelines or the pattern in social media. What is important is the text and how does the DPA will use it when it's time to decide if something is compliant or not. And you have different systems. You have the recommendation. If we receive a complaint, we are going to investigate and then to take a decision. And on some decision we took lastly at Kenneth, for example, on the cookie, on how to accept cookies, the two cases, Google and Facebook, was about fairness and was about transparency. It was not fair to use six, if you remember, 6 screens before you could say no, when you had only to accept on the first one. This was about fairness, I think. It was not, I don't think we used the fairness, but it was about fairness, I think. Yes, so that's why I think it's not because all the text, the GDPR has not been used today that it won't be in the future.
Any other question from the audience? Here we have one.
I think it's, I'm not a lawyer, absolutely not. I'm a designer with a design program at a university in the Netherlands. And what I'm taking away with me today is that we need to do even more on training designers on how to have the discussions, because it's not just them not knowing the legislation, but it's also that they're lacking the vocabulary to actually push back against product managers and business owners. So that's something I'm taking with me today.
Somebody wants to comment?
Yeah. Well, I mean, I would say yes, absolutely correct. And it's not necessarily about pushing back specifically, because I'm trying to avoid this connotation that ethical design is a hamper, is going to hamper innovation, that it's going to slow us down. Designers know that it might be a constraint, but designers also know that that just is a seed of innovation. It doesn't reduce the possibility space, it just generates new possibilities. But I want to, as I say, take that momentum and kind of invert it and say, okay, let's use this requirement to behave more responsibly as a way to excel, to build better stuff that helps, you know, humanity and the technology industry flourish, rather than just as a kind of act of, you know, folding our hands and saying no.
Yeah, can I add something? I think that what you mean is very true, but it's also the same for computer science students, for example, engineering students. It's exactly the same. So what I see, at least with our PhD students and master students, and we're working in between data protection and computer science and ethics as well, is that they really come up to you and ask you, okay, this text, I read it, it's the text of the law. What do I do with that, right? So how do you actually implement it? It's always the same problem. And then they tell you, yes, but then you tell them, yeah, but read the guidelines, for example. And the guidelines, most of the guidelines, official guidelines that you can find are written in a way that is absolutely ununderstandable for anybody that does not have a legal background. So what do? They look online. They look online, they find blog posts. Most of the blog posts are absolutely wrong in the terms of the arguments and the instructions that they give. So I don't know, there is, according to me, to what I see really in practical research and you know, really also training with younger students, is that it's very hard still to bridge that gap and really find reliable, understandable, implementable information that makes sense to them and still is accurate. And I think this is one of the gaps that we need to bridge, and it's the same for design students, I would assume.
Just a few comments from my side as a follow-up. From my personal perspective, it's not only a problem with students, it's a problem with lawyers.
Yes.
Yeah, definitely. My personal experience, it's a huge problem with so-called compliance managers. When they start actually implementing the data protection related provisions in practice. Some of them are very black and white and clear, easy to be implemented. When we come to the point when things like a data protection impact assessment, privacy by design and so on has to be implemented, these principles, then when it's, when there is a need for reading guidelines, recommendations, and so on, it's huge problem.
Thank you. Regis, last words? Because
Yes, it's marketing time. On the data design, you have some recommendation for designers with some words they can understand in both French and English. And that was our main goal when we created this platform. And from the other side, at CNIL, now we introduced some legal design courses for lawyers. So it's possible for the lawyers to be introduced to legal design. It's only the beginning, but we started in 2019, but we go step by step, and the design much more important this day at CNIL than it was 3 years ago. And it's a general process, but we'll see.
Thank you for the publicity. So we arrived to the end of our panel. Thank you so much for your important questions. Thank you for engaging with us and with the panel. Thank you for all of you. We will be here, and if you have further questions, you can email us, or we can interact until tomorrow.